All right, let me ask you something. What does a Supreme Court judge and your local mail carrier have in common? I know, it sounds like the start of a bad joke, right? But the answer is actually hidden inside this one super powerful legal definition. It's the bedrock, the absolute foundation of public accountability. So, let's unpack it together. I mean, think about it. On one hand, you've got this immense power, the prestige, the robes, and on the other, you've got someone delivering your packages. They seem like they're from different planets. But you know what? The law, it sees something else. It sees this invisible thread, a fundamental connection, a shared responsibility that links them together. And that connection is this. They're both key holders. Yeah, key holders. Each one has been entrusted with a key to something absolutely vital. A judge, they hold the key to justice. The mail carrier, they hold the key to our entire communication network. See, they're both stewards, guardians of a critical government function.
And here's where it gets really interesting. The law doesn't care about the pay gap or the fancy titles. It looks at both of them through the exact same lens. A single, powerful, overarching definition. You can think of it like a master blueprint. It's what determines who is accountable to us, the public, and who isn't. So let's start breaking that blueprint down.
Okay, Section 1, the accountability blueprint. Look, before we can even talk about accountability, we have to get crystal clear on one thing. Who exactly is a public officer? So here it is, the big definition. A public officer is any individual who participates in performing public functions. Now, the two magic words there are participates and public functions. It's not about the fancy title on your door or the corner office. It's all about your active role in the real work of government. And just look at how broad this is. We're talking employees, agents, subordinate officials of any rank or class. This isn't an accident. The law is intentionally casting a super wide net here. It's basically saying, hey, if you're doing the public's work, we don't care if you're the department head or the brand new entry-level clerk. You're on the hook. You are accountable. So why do we care? Why does this one definition matter so much? Well, this isn't just some dusty legal trivia for first-year law students. No way. This is the starting line. It's the foundational block for pretty much every single law dealing with crimes in public service. Think about it. You can't prosecute bribery. You can't go after corruption or abuse of power if you can't first define who has that power. You have to lock down the who before you can ever get to the what they did wrong. All right, Section 2, who holds the keys? So we know these people exist, these key holders. But how do you become one? How do you get one of these keys? Well, the law is very specific. It lays out exactly 3 ways in. And here they are, the 3 paths: by direct provision of law, by election, and by appointment. That's it. You can think of these as the only 3 legitimate key-cutting machines in the entire government. If you get a key any other way, guess what? It's a counterfeit. The law won't recognize it. So let's take a closer look at each one. First up, by law. This is a really interesting one. This is where the law itself, the actual text of a statute, creates a job out of thin air and spells out its powers. A perfect example is a public prosecutor. Their authority doesn't come from a boss appointing them. It comes directly from the words written in the legal code. The key is literally forged in the law itself. Okay, path number 2 is the one we all know best, by election. This is democracy in action, right? Here, the key isn't made by lawyers or politicians in a back room. Nope, it's given directly by us, the people, every time we go into that voting booth. When you cast a ballot for a mayor, a governor, a representative, we are all collectively handing that person a key and saying, we trust you with these public functions. And that brings us to our third and final path, by appointment. This is basically where one key holder gives a key to someone else. It's a transfer of authority. So a president appoints a cabinet secretary, or a governor picks someone to be on a state board. The key is passed down from someone who already holds a legitimate key, what the law calls a competent authority. Section 3, the job, not the title. Okay, so we've covered the how someone gets the key. Now we need to talk about the what. What do they actually do with that key? In legal terms, this is all about something called the actus reus. It just means the physical act. So this core act, this actus reus, it's really simple. It's the actual performance of public duties. It's not about theories. It's about the tangible things you do that wield government power. Are you the person stamping approved on a permit? Are you enforcing regulations? Are you in charge of public money? It all comes down to the verb. What action, what function are you performing for the public? And this is a fantastic way to see the difference in action. Take a member of a local zoning board. They are exercising real government authority. That's a public function. So yes, they're a public officer. But now look at a private IT contractor hired by the city. They're providing a service, fixing computers, managing a network. They're a vendor, not an officer. And that distinction is absolutely critical in the eyes of the law. So here's the bottom line for this section. The law just cuts through all the noise, the fancy job titles, the confusing org charts, and it asks one really simple question. What do you actually do? Because that is where the real power is. And where there's power, there's responsibility.
Moving on to Section 4, accepting the responsibility. So we've talked about the physical act, the actus reus, but that's only half the equation. The law also cares deeply about the mental state. Legal pros call it the mens rea, and what it means is it's not enough to just do the job. You have to knowingly accept it.
You see, you can't just accidentally become a public officer. The whole system is built on the idea that you have knowingly, consciously taken on this role and all the duties that come with it. You don't just trip and fall into a position of public trust. It's an intentional act. You have to accept it. And here's a great way to think about it. When someone takes an oath of office, or signs that employment contract, or formally accepts an appointment, it's the exact same thing as clicking that little I agree box on a software license. You are formally saying, yes, I understand. I acknowledge the special responsibilities and the higher standards of this job. You are consciously opting into accountability. Okay, Section 5, why this definition matters. We've pulled this definition apart piece by piece, but now we get to the most important question of all. Why? Why does the law get so incredibly detailed, so meticulous about all this? I mean, seriously, why build up all this complex legal machinery just for a few sentences buried in a law book? Well, the answer really gets to the core of why we even have government. It's all about protecting something that is unbelievably valuable and at the same time incredibly fragile. And there you have it. The harm the law is trying to prevent isn't just about stolen money or a broken rule. No, the ultimate damage, the thing this is all designed to stop, is the misuse of public trust. That trust, it's like the invisible infrastructure that holds our entire society up. Every single government function, everything we rely on is built on that foundation of trust. And when that trust gets broken, believe me, the consequences are huge. They ripple out everywhere. This is not a victimless crime. It corrodes our faith in the very institutions we need to function. It can literally grind essential services to a halt. And worst of all, it sends a message that the rules are for suckers, that they don't apply to everyone. And that just destroys the rule of law and creates massive systemic inequality. That's what's truly at stake here. All right, our final section, number 6, gray areas and get-outs. Now, it's important to know this law isn't just a big, dumb hammer. It's not a blunt instrument. It actually recognizes that things can be complicated, that there's nuance. So let's talk about the defenses and the exceptions. See, the law always looks at context. It's a balancing act. On one side of the scale, you have what are called aggravating circumstances, things that make an offense even worse, like if someone deliberately and maliciously abused their power. But on the other side, you have mitigating circumstances, things that might lessen the blame, like if someone was acting in good faith or was genuinely unaware they were crossing a line. The point is, intent really, really matters. And out of all that context, a couple of key defenses can emerge. The first one is basically no authority. That's where the person argues, hey, you're saying I misused my key, but my key never actually opened that door in the first place. I didn't have that power. The second major defense is good faith. This is someone saying, okay, maybe I did the thing, but I honestly had no idea I was overstepping my bounds. What this all shows is that the law is designed to target real, genuine misconduct, not just honest mistakes. So when you put it all together, you can see this definition is so much more than just some abstract legal theory, right? It's a living, breathing blueprint for accountability. It's a system that impacts your life every single day, whether you realize it or not. So I'm going to leave you with one final thought. Now that you know the blueprint, who in your world holds a key?